Hello and good afternoon, everyone. Happy that I'm back finally to record a few more tips for you. I'm sure that you are all very deeply engaged in your books and studying for the upcoming examinations next week. I've been asked specifically by Yasmin Mohammed to just touch on a few tips for the RAF section of the exam paper. So I would like to start off where we have an example of a passenger who was seated in a motor vehicle and driven by Y. Y was attempting to overtake another motor vehicle when it was inopportune to do so. Recklessly then overtakes the vehicle, overturns, and there's no collision with another vehicle. And of course, poor client, passenger who sits in the vehicle, has suffered injuries. So I've looked at the past papers to see whether this question has in fact come up, and indeed it has. And the questions that were asked in the past question paper related to: does the passenger have a third-party claim? And if so, is his claim limited? In the old Act, his claim was limited. However, with the new amendment, the passenger has an unlimited claim. So I'm hoping that you would be able to understand that the passenger has a full claim. The question that follows was: does the passenger have any claim against the driver? And by now, I'm sure that you have all learned through your studies and through your experience that there is no such a claim against the wrongful driver, because the RAF steps into the shoes of the insured driver. Whether the plaintiff, your client, will qualify for general damages will largely depend upon the severity of his injuries. And to be able to claim for general damages, one will have to show, first of all, that the damages or the injuries is of a serious nature, and that there was a 30% or more impairment of his bodily functions. Now again, that depends upon the facts of the case. If it is a ballerina and her little toe is very important, it might seem very trivial that she's unable to prove her 30% impairment. However, being a ballerina, her foot is nevertheless important, and therefore it might be considered a serious injury. So each case will then have to be determined on the facts of the case, and of course the extent and the nature of the injuries. However, if Peter, in this case, Peter the passenger, was seriously injured, one needs to understand the various heads of damages. Please look at your notes as to what constitutes general damages and how does one in fact quantify it. That will also include past medical expenses, which are actual expenses, future medical expenses, past loss of earnings, as well as future loss of earnings. Of course, this will depend on whether your client, Peter the passenger, was in fact employed and whether he in fact had a loss of income. So Miss Ballerina, in this particular case, if she has not been a professional ballerina in the sense that she had no shows and she did not have an income as a result of her ballet activities, highly unlikely that she would be able to claim for that. However, she might be able to claim in other capacities if she has been working as a professional assistant in a legal firm and she was off duty for a substantially long time. I hope that then answers the question about Peter the passenger or Betty the ballerina. The question often has been asked in the paper as to whether the driver is able to institute a claim. Unfortunately not. The driver, who is the sole cause of the accident, is unable to, and therefore would not enjoy a claim against the Road Accident Fund. Hope that sufficed, and I wish you all the best. Thank you.